Chicago conspiracy theorist Alex Jones arrived at a Texas courthouse for his defamation trial for calling the Sandy Hook Elementary School attack a hoax with the words, "Save the First" scrawled on tape covering his mouth. Although Jones portrays the lawsuit against him as an assault on the First Amendment, the parents who sued him say his statements were so malicious and obviously false that they fell well outside the bounds of speech protected by the constitutional clause. The ongoing trial in Austin, which is where Jones' far-right Infowars website and its parent company are based, stems from a 2018 lawsuit brought by Neil Heslin and Scarlett Lewis, whose 6-year-old son was killed in the 2012 attack along with 19 other first graders and 6 educators. Here's a look at how the case relates to the First Amendment. Are all defamation lawsuits First Amendment cases? They are. Typically, the first question jurors answer at trials is whether the speech qualifies as unprotected defamation. That led exasperated Judge Maya Guerra-Gamble to enter a rare default judgment, declaring the parents winners before the trial even began. It might suggest Jones knew certain evidence would doom his defense. It is reasonable to presume that Jones and his team did not think they had a viable defense. And Jones made similar arguments in a deposition. If questioning public events and free speech is banned because it might hurt somebody's feelings, we are not in America anymore, he said. Jones, who had said actors staged the shooting as a pretext to strengthen gun control, later acknowledged it occurred. What are key elements of defamation? Defamation must involve someone making a false statement of fact publicly, typically via the media, and purporting that it's true. Is it easier for non-public figures to prove defamation? Yes. They must merely show a false statement was made carelessly. In New York Times v. Sullivan in 1964, the Supreme Court said the bar for public figures must be higher because scrutiny of them is so vital to democracy. They must prove actual malice, that a false statement was made with knowledge that it was false, or with reckless disregard of whether it was false or not. Jones argues that Heslin did just that, entering the national debate over guns by advocating for tougher gun laws on TV and before Congress. He asked them to award the plaintiffs $1. First Amendment issues influence the trial's outcome. Indirectly, yes. Jones can't argue that Hess not liable for damages on the grounds that his speech was protected. The judge already ruled he is liable. But as a way to limit damages, his lawyers can argue that his speech was protected. Jurors could say, Jones' defamatory statements is actually something we don't want to punish very hard, said Kevin Goldberg, a First Amendment specialist at the Maryland-based Freedom Forum. Could Jones have won if the trial was all about free speech? He could have contended that his statements were hyperbolic opinion, that wild, non-factual exaggeration is his shtick. It was a verifiable fact the massacre occurred at Sandy Hook, said Solomon. But Covert said defamation is always a challenge to prove. I wouldn't discount the possibility Jones could have prevailed, he said. In 2011, the High Court voted 8-1 to overturn a verdict against the Kansas-based Westboro Baptist Church for picketing military funerals with signs declaring that God hates the U.S. for tolerating homosexuality. As a nation we have chosen to protect even hurtful speech. But it and the Jones case have key differences. They were both extreme, outrageous, shocking, deplorable. Not about any one person's reputation, Goldberg said. He added, "I'd be shocked if Jones' case ever ended up in the Supreme Court." For more of the AP's coverage of school shootings, https://appnews.com/school shootings.